Stop scrolling. Because what I'm about to tell you didn't just change a law, it quietly changed the balance of power in America. For decades, gun owners were told, "This is settled law. There's nothing you can do." That was a lie. And last year, a federal court just proved it. This isn't a rumor. This isn't speculation. This is a real ruling that hit like a legal earthquake. And most Americans have no idea it even happened. Here's the scary part. If you own a firearm, if you carry one, if you plan to buy one someday, this decision already affects you. And the reason you haven't heard about it? Because it doesn't fit the usual narrative around gun laws in the USA. For 45 years, one legal framework quietly controlled how courts treated the Second Amendment. Judges relied on it. States hid behind it. Legislators built entire gun control systems on top of it. It shaped bans, restrictions, licensing schemes, everything. And now, that foundation just cracked. Not weakened, not questioned. Cracked. Late in 2024, the Second Circuit Court of Appeals, one of the most influential federal courts in the country, issued a ruling that stunned constitutional scholars. This is the same court that oversees New York, Connecticut, and Vermont, states known for some of the strictest gun laws in the USA. And yet, this court did something unexpected. It didn't ask whether a gun law was reasonable. It didn't balance your rights against government interests. It didn't play the old legal game. Instead, it looked backward, way backward. Back to history, back to tradition, back to the actual meaning of the Second Amendment. That shift alone is massive. But what came next? That's where everything changed. The case itself didn't sound explosive. No dramatic name, no viral headlines, but buried inside it was a legal move that effectively erased nearly half a century of precedent. The same precedent used to justify modern gun restrictions. Think about that for a second. 45 years of accepted gun control logic, undone by one ruling. And here's the tension no one is talking about. If this reasoning spreads to other circuits, and it can, it puts dozens of existing gun laws on borrowed time. Licensing rules, carry restrictions, so-called sensitive places, even long-standing bans. This wasn't just a win, it was a warning shot. Because once courts stop deferring to lawmakers, once history becomes the standard again, the entire battlefield around gun laws in the USA shifts overnight. And the next question becomes terrifying for regulators and empowering for citizens. If 45 years of restrictions can fall this fast, what's next? Here's where the story takes a turn that makes lawmakers nervous. Because the court didn't just rule on a case, it rewrote the rulebook. For decades, courts used a balancing test when judging gun laws in the USA. Judges would ask, does the government have a good reason? If the state said public safety, most laws survived. That's how restrictions stacked up year after year, quietly, legally, almost automatically. But this time, the court refused to play that game. Instead, it asked a single, dangerous question. Is this restriction rooted in America's historical tradition of firearms regulation? That question changes everything. Because when you actually look at history, real history, not modern assumptions, many of today's gun laws don't exist there at all. No analogs, no tradition, no precedent. And the Second Circuit said that matters a lot. The court made it clear. If a restriction didn't exist around the founding era, or doesn't closely resemble one, it doesn't get a free pass just because lawmakers feel it's necessary. That's not a tweak. That's a demolition charge. This approach traces back to the Supreme Court's Bruen decision. But here's the twist. Many lower courts tried to slow-walk Bruen. They narrowed it, softened it, interpreted it gently. The Second Circuit didn't. They leaned into it. Hard. They explicitly rejected the old interest-balancing logic that had dominated since the late 1970s. The very logic states relied on to defend modern gun control structures, which raises a chilling possibility. If courts must now justify gun laws through historical proof, who carries the burden? Not gun owners, the government. And suddenly, states with aggressive gun laws in the USA are scrambling. Because proving historical tradition isn't easy when many of these laws were invented in the last few decades. That's why this ruling sent shockwaves through legal circles, even if the media stayed quiet. Behind the scenes, attorneys immediately began rereading statutes. Advocacy groups started preparing challenges. State officials realized something uncomfortable. This case can be cited. This reasoning can spread. And other circuits are watching. And here's the pressure point. Once one federal appeals court firmly rejects 45 years of legal doctrine, it invites others to do the same. That's how legal dominoes fall. Slowly at first, then all at once. So now the question isn't if this affects other gun laws in the USA, it's how fast. Because if a court can say, this restriction has no historical basis, then what happens to carry permits? Magazine limits? Location-based bans? The answers aren't theoretical anymore. They're coming. And in Part 3, we're going to talk about the real-world consequences. What this means for gun owners right now, what states might do next, and why this ruling could be heading straight for the Supreme Court. Because the biggest shock hasn't happened yet. Now we arrive at the moment everyone's been avoiding. Because legal theory is one thing. Real-world consequences, that's where this ruling becomes explosive. Here's what this actually means for gun laws in the USA. Starting now. The second this decision was published, it became a weapon. Not a physical one, a legal one. Defense attorneys can cite it. Plaintiffs can build cases around it. Judges can rely on it without fear of stepping outside precedent. And they already are. States like New York and Connecticut know exactly what this signals. They're not celebrating, they're preparing. Because when courts stop deferring to lawmakers and start demanding historical proof, entire regulatory systems suddenly look fragile. Think about it. Many modern gun laws weren't created because of history. They were created because of fear, politics, headlines, pressure. But fear isn't a historical tradition, and politics isn't a constitutional standard. That's the trap this ruling sets. For gun owners, this opens doors that have been locked for decades. Laws once considered untouchable are now vulnerable. Laws that survived every challenge under the old framework may not survive a single challenge under the new one. That's why legal analysts are using words like cascade and chain reaction. Because if one circuit can do this, others can follow. And when circuits start disagreeing or aligning strongly, there's only one place this ends up: the Supreme Court. That's the part no one in power wants to talk about. If cases built on this reasoning reach the High Court, it forces a national reckoning, a clear answer, a unified standard, and potentially the final dismantling of the post-1979 gun control framework. But here's the twist. States won't go down quietly. Expect new laws written to look historical. Expect emergency regulations. Expect legal gymnastics designed to survive this new test. The battle over gun laws in the USA isn't ending. It's entering a new phase, a smarter phase, a quieter phase, a more dangerous phase for bad laws. And for everyday Americans, this moment matters more than most elections. Because courts move slower, but when they move permanently. This ruling won't trend on social media. It won't lead the evening news. But years from now, historians may point to it and say, that's when the tide turned. So whether you support gun rights, oppose them, or are still figuring out where you stand, one thing is undeniable. The legal ground just shifted. And once it shifts, it never goes back the same. The only real question left is this: will people pay attention before the next ruling drops?